Hello and welcome, everyone. Today we are going to take a look at a decision from Germany, which was delivered by the District Court of Munich in May last year. And it is a case between InterDigital as the claimant in these proceedings and Lenovo on the defendant side. This is an interesting case because it is a case which is part of a broader dispute between the two parties, which was carried out in several jurisdictions around the world. And here in the specific case, what was interesting was that one of the elements which the court addressed was the determination that was made on front terms and conditions between the same parties in a court in another jurisdiction, in a UK court in the present case. So here the court had to give some input on that, and I think this is also one of the most valuable elements of this decision that we're going to take a look at in a moment. Before we do that, let's take a look at the story behind the case, as we always do. The case between InterDigital and Lenovo started already back in 2008. This was the first time where InterDigital approached Lenovo. So this is almost 17 years ago when negotiations started. They were not successful, and that's why in 2019, in August 2019, litigation started. InterDigital filed lawsuits against Lenovo in the UK. These UK proceedings are interesting for our case here. Of course, this litigation, as I said already, expanded to further jurisdictions as well. But these UK proceedings were particularly interesting here because what the UK court did, apart of course from deciding on infringement and the technical side of the things of the dispute here, was to also set the terms for a global front license to InterDigital's portfolio. This was a decision which was delivered in March 2023. What was interesting here, we're going to take a look at in a moment, in a more detail, what the front determination was all about. But maybe here, just for our information to keep in mind, the terms that were set by the UK High Court were referring to a license for the period 2007 to 2023. This means that this license agreement was mostly looking at the past, because of course the decision came in March 2023, and the license terms were to expire at the end of the year, basically. So the license agreement was to expire at the end of the year. So this again was a decision which was mainly looking at the past and not so much going forward. What was interesting also here was, maybe exactly because the rates and the terms determined were mostly addressing the past, was the fact that apart from the actual licensing fees, the court also determined here a significant amount of interest payments that needs to be paid by Lenovo to InterDigital, especially for the past uses of the technology. This first instance determination was appealed by both parties. Maybe here, very generally, InterDigital contested the rate calculation and the way the court basically made the front determination here. Lenovo, on the other hand, focused more on the aspect of the interest payment. So we're going to, again, take a look at that in a moment in more detail. Of course, what happened here was that we had, let's say, a solution or a decision that would cover the past, but there was no decision or no solution covering the future. So what would happen after 2024, with the beginning of 2024? So to cover that, InterDigital made an offer to Lenovo in September 2023 for a license which would cover 2024 until 2027. And at the same time, more or less, it also filed a lawsuit in Munich. In Munich, this is the decision that we're going to discuss today. Lenovo, before having received the lawsuits filed in Munich, filed its own proceedings against InterDigital in the UK. And especially what Lenovo did here was to ask the High Court in England to set the terms for a global license that would start in January 1st, 2024. So what we had as a situation there, maybe just to summarize that, was that we had a front determination between the parties in the UK, which would cover mostly the past. We had then litigation starting in Germany with a view at the future, especially with the start of 2024. And at the same time, we had the proceedings in the UK. First of all, the appeal proceedings pending regarding the first instance front determination and new proceedings that would refer to a license starting at January 1st, 2024. Of all these proceedings that were pending, the first decision was delivered by the District Munich Court. And it's the ruling we are going to take a look at today from the 2nd of May, 2024. The outcome of this decision was very much in favor of InterDigital. The court, among other remedies, also granted an injunction against Lenovo in these proceedings. 2 months later, we had the decision of the appeal court, in the Court of Appeals in the UK, and there the court basically delivered a ruling which changed to a certain extent the front determination of the High Court in first instance, increasing the royalty amount payable to Lenovo, to InterDigital, by Lenovo, and this also, of course, raised the amount of the interest payment that needs to be paid as well. Almost 3 months later, then, in October 2024, the parties announced that they had agreed to enter into a new license agreement where the final terms would be determined in arbitration. This means for us, for our proceedings here, that most likely they will not proceed anymore in the appeal stage, so we won't have any other decisions here. And it's also very unlikely that we will get the decision of the arbitral tribunal on the actual final terms, because as usually arbitration is confidential and the outcomes, the awards are not really publicly available. So it is most likely that, especially for these proceedings here in Germany, in Munich, we will not have a new decision in the appeal instance. Before going into the actual decision of the Munich court, as I mentioned already, maybe it's helpful to have a brief look at the front determination by the High Court of Justice in England in the first instance. So what were the terms that the court set there, and how did it proceed? How did it reach its decision and made the determination? I think important, we mentioned that already, the license would cover the period 2007 to 2023, so almost 16 years, again focusing on the past. The court then said that for this period, a lump sum payment should be paid by Lenovo to InterDigital, and this was a payment of $138.7 million. What was interesting here is that the court applied the same rate for past and future sales. Again, here, of course, the reminder: the major part of the license agreement covered the past. So this was the actual amount that was adjudicated here in favor of InterDigital. And then the question is, how did the court make this determination? So what was the methodology used? There was a lot of detail in this decision, which, of course, we cannot really cover here. But I think generally what we can say is that the court used the comparable licensing methodology. So in very simple words, it tried to look at existing agreements, especially InterDigital agreements with other licensees, and then tried to identify which of these agreements are closer to Lenovo, which licensees and their business is closer to Lenovo. And then on that basis, determine what would be the rates that should be granted to Lenovo. The actual license agreement on which the court relied at the end of the day was a license between InterDigital and LG from 2017, which interestingly covered also the past mainly. So it covered the period between 2012 and 2018. In the eyes of the High Court, this was the best comparable. So this was the license agreement that the court really based its calculation upon. Why? Because the court found that Lenovo and LG had a similar sales mix between 3G and 4G handsets, and they had a similar split between the geographies. So the sales were in a similar way splitted between developed and emerging markets, for example. So this was the main source for the front determination, this license with LG from 2017. And what the court did here, and we're going to see in a moment why this was interesting, or what role did it play in the German proceedings, was that it applied a so-called adjustment ratio of 0.728. What does this mean exactly? What is this adjustment ratio? Generally, if we put it, let's say, in a simple way, we have, of course, two agreements, which are agreements signed or that should be signed with similarly situated licensees, but of course not identical licensees. So there is a need to adjust the one agreement to mirror differences which are there between the two licensees, for example, in the geographic split of the sales, etc. And for doing that, the court used a ratio, meaning that it took the terms of the LG license and applied this ratio to adjust these terms to the terms that Lenovo should be offered. We're going to see again, as I said already, in further going on in the decision that the court addressed this adjustment ratio and had some thoughts about that. Apart from that, we had, as we said already, there was also interest awarded to InterDigital, and this was here a significant amount. It was $46.2 million, covering exactly the period from 2007, which amount was added on top of the lump sum payment. So this was generally the front determination in the UK that had happened before the proceedings in Munich here. And as we're going to see in a moment, it also was discussed in the Munich proceedings as well. Now, if we look at the decision now of the District Court of Munich, of course, we had a finding here that the patent in suit is infringed. So this is something that the court confirmed. And then on the front side of things, we had the court dealing with the front defense that Lenovo had raised here. As it is most often the case in the German courts, in German litigation, this front defense was based on competition law considerations. So especially here, an abuse of a market dominant position. This is the way these arguments are being made in German cases usually. So the implementer basically argues that in measures, including an injunction, of course, but also the recall and destruction of infringing products that might exclude the implementer from the market should not be granted, although, of course, we have infringement, because by filing an action that could lead to such exclusion, the SEP owner abuses a market dominant position. So this was the basis here also for the arguments of Lenovo. The court, in a first step, looked at whether there is a market dominant position on InterDigital's side. And it confirmed that it is. Interestingly here, the court focused let's say, on very technical arguments, on basically on the essentiality of the patent in suit. Because it said that market dominant position is given since the teachings of the patents in suit must necessarily be used for applying the standard. And from a technical viewpoint, it's not possible to replace the underlying invention by another one. And apart from that, the court also mentioned here that in the proceedings, there was no indication that an equivalent technical alternative exists. So this, again, the assessment of whether a market dominant position exists or not focuses more on the technical aspects, especially the essentiality of the patent in suit. If this is given, then here, as the Munich court did and the German courts often do, then they accept that there is a market dominant position. However, the court then held that InterDigital did not abuse this market dominant position at any time in the present proceedings or in the present case, because more or less the court was satisfied with the way InterDigital had behaved. On the other hand, the court found that Lenovo did not behave in a front-conform manner. So the analysis of the court, which is particularly interesting for us, revolved around the issue of willingness. So around the question of whether Lenovo acted as a willing licensee, someone that was intending to take a license and also did its best, let's say, to also sign a license. To make this assessment, the court used a standard which is very well known in Germany in the last years, and it goes back to a decision of the Federal Court of Justice in Sisvel versus Haier back in 2020. Here, just some of the main elements which the court confirmed in this case as well. The court placed a lot of weight on the engagement in the negotiations, looking of whether Lenovo in the present case had acted in a target-oriented manner. This is a very important element of the German case law, which goes back to the Court of Justice of the EU decision in Huawei ZTE, which was the landmark decision on fraud cases in Europe delivered almost 10 years ago. So what does this mean, this target-oriented engagement in the negotiations? This means that it's not just sufficient to declare that you're willing to take a license. Of course, this is also required as well as an implementer. If you are informed that you are infringing a patent, you should declare that you are willing to take a license. But apart from that, there is also this qualitative element that you need to subsequently act in a way that someone would act that is interested and wants to take a license. So in a target-oriented way. And this is here, as we're going to see in a moment, the main point of criticism that the District Court of Munich raised against Lenovo's behavior. Two other elements here, which have been also followed by courts in Germany in the past as well, but I think interestingly to keep in mind and to repeat here, is that willingness is not static, meaning that you cannot really say that the implementer was at some point willing, and this would apply then for the rest of the negotiations of the parties. But this can go also both ways. You cannot really say that an implementer was initially unwilling, and this is the only assessment you need to do. You need to look at the overall behavior, and you need to look at the behavior from a more holistic perspective, so that it can be that someone who initially was unwilling changed its behavior or changed its views or changed its heart going forward and engaged in a very positive way and target-oriented way at some later point. So this needs to be taken into account by the court, but also, of course, the opposite situation. So if you have someone that was initially very willing, but at some point lost interest and did not engage in the negotiations sufficiently and effectively anymore, this again needs to be taken into account. So it is not a static approach. You need to look at the behavior over time and from a holistic point of view. What the court also stressed here is that willingness must also be continuous. So it should not only be there immediately after having been informed that there is infringement, but you need to do it throughout the negotiations. And the reason for that, according to the court here, is that if you require from the patent owner to tolerate, to a certain extent, the unlicensed use and infringement of its patents until there is agreement for a license, you can only do that if the one who free rides the technology and uses the technology without a license is also prepared and willing to take a license. Because if this is not the case, then in the view of the Munich District Court, you cannot really withhold an injunction and ask from the patent owner to tolerate and accept that there is infringement without any remedies. Then the court said what the question is that you need to answer when assessing willingness is what would a reasonable party do, which is interested in a successful negotiation outcome at the specific stage of the discussions to promote this goal, considering the specificalities of the individual case. So this is basically what you need to ask yourself when you look at the behavior of a party in the negotiations. And I think this gives us basically two takeaways. One, and I think it's important, there is a need to have a case-by-case assessment of willingness. So the court mentioned here as well that a general definition of the requirements is not possible. Maybe to give an example, you cannot really say that if an implementer receives a notification of infringement, he must answer, for example, in 2 weeks. Having like a general definition of the timeline that needs to be followed. The court said that here the circumstances and the cases differ from each other, and you need always to take a case-by-case assessment here. So you need to really look at how the specific negotiations went, how the parties specifically acted in the case, what information was exchanged, how was information processed, and what the answers and the feedback. So you need to really look at how the specific parties acted. And the second takeaway here is that there is a duty, according to the district court, to promote negotiations when you can expect to take the next step in the negotiations based on business practice and the principle of good faith. Meaning, and we're going to see that the court really considered that going forward, that you cannot really just basically stay in touch, and this is not sufficient to say that I'm negotiating, but if there is a stage reached in the negotiations where, based on the regular course of regular business negotiations and the principle of good faith, of course, you would expect the one party to take a next step to make an active move towards taking a license or signing a license, then there is, in this case, a duty to do that. So you need to be proactive. You need to go and take the next step. If you don't do that, then there is a risk that you will be considered unwilling. And this is, again, something that the court really looked at and also criticized with respect to Lenovo's behavior in the present case. So that was the standard that the court applied in the present case. And then let's take a look at the outcome and what was the court's assessment of Lenovo's behavior. In general terms, the court found that Lenovo applied a holdout tactic here, and the court said that this holdout tactic is not in line with the legal order, and it's something that InterDigital must not accept. So the court was convinced here that, as we said already, Lenovo did not act in a front-conform manner and saw, particularly in its behavior in the negotiations, etc., a very clear indication of holdout. It highlighted some of the points we're going to take a look at now. There was, let's say, more analysis of the court in this regard, but some parts of the judgment were redacted, so we don't know every detail. But I think also the aspect that the court mentioned and highlighted are useful to understand the thinking of the court. So what the court basically said here is that at that stage where we are now, although there are only minor differences regarding the license rates, Lenovo was not concerned with finding a solution that would satisfy both sides. On the contrary, the court saw in Lenovo's behavior that it intends to negotiate, not so much to sign an agreement and find a solution, but to strengthen its own positions through further delay. Although in economic terms, in the eyes of the court, an agreement imposes itself on the parties, more or less. So basically what the court said here is that looking at how the situation is and how close the parties potentially are to finding a solution also for the future, the fact that this solution was not signed, although it was very clear that the parties were very close and it wouldn't take much basically to reach agreement. Continuing negotiating was more or less an attempt to delay things further in order to strengthen your position in the negotiations and increase your leverage. So this is what the court criticized here regarding Lenovo's behavior. And it was also clear in saying that Lenovo, in the eyes of the Munich court, was not interested in a fast solution here, but intended to impose a positive outcome through further delays. And in this respect, the court did not only look at the actual situation here, where we had, of course, already rate determination. In the UK, we had an offer following this rate determination from InterDigital side going forward. But here, the court made this, what we mentioned before, the more holistic view of the whole situation here, and said, if you consider that there had been already multiple offers exchanged between the parties and many offers on the InterDigital side to Lenovo, and that the negotiations started back in 2008, so almost 15, 16 years ago, it was now Lenovo's duty to do everything it could to successfully conclude a license. This is the element we discussed before. If you remember that we said that at some point you need to make an assessment, and if based on the business practice and the principle of good faith, you could expect that the parties are going to move forward and are going to take the next step. Then if they do not do that, this is an indication of unwillingness. And this is what the court criticized here, that just having conversations and exchanging emails was no longer sufficient at this stage. So after you have been in discussions for almost 16 years, after you have gone through proceedings, infringement proceedings in different jurisdictions, after you have had the front determination, after there are further offers on the table, then just continuing having conversation and exchanging views was not sufficient. Lenovo would have been expected by the court to have done more to sign an agreement, because now it was, in the eyes of the court, the burden on Lenovo to justify and legitimize the use of the patents. And this was something that they should have done now. They should have done more than just keeping in touch and exchanging information and having conversations. So this is here a manifestation of what we mentioned before, this requirement to have a target-oriented engagement in the negotiations. And the target-oriented means, depending, of course, on the specific situation, that at some point you need to do just more than just keeping the conversation alive. Then the court also mentioned here that Lenovo did not accept InterDigital's offer, which was received before the statement of claims was served to Lenovo. And in the eyes of the court, this was not very clear why it was justified, because on the contrary, the court felt that the rejection of this offer was more Lenovo intended to take advantage of InterDigital's clearly articulated interest to find a final solution by this offer made. So here the offer was also offering, let's say, a total solution which would end litigation and basically create peace. And the fact that InterDigital clearly articulated that, but on the other hand, Lenovo did not accept the offer, was seen by the court as an indication that Lenovo was again trying to take advantage of the situation. Now, the court then turned to the behavior of Lenovo, and especially the behavior regarding the potential terms that should be the terms of a license agreement going forward. And this is where the front determination in the UK started playing a role in these proceedings as well, because what Lenovo did was to insist that for 2024 and onwards, the same rate determined in the UK, which was $0.17 per device, for the past, however, for the period 2007 to 2023, should apply also for the future. So the argument here, or maybe the point, the position of Lenovo was that for the future, for going forward from 2024 onwards, you should basically use the same rate that was determined in the UK by the High Court, however, for the past, for 2007 to 2023. And the Munich court was not satisfied by this behavior or criticized this behavior. One obvious point, of course, was to say that making this as your position and insisting on that is not really very productive, because Lenovo should have been aware that this is not a rate that InterDigital would expect to accept. You would definitely see here that this rate was below InterDigital's expectation. And this was clear, of course, not only in the proceedings in the UK, where you had discussions and the ask for InterDigital was higher, but also the fact that InterDigital was not satisfied or was not happy with this rate was very clearly articulated in the fact that they had appealed the UK rate setting. So although knowing that initially InterDigital had a higher expectation on the rate, going forward they attacked the rate determination because they were not satisfied by that. They believed there should have been more. Nevertheless, and despite all that, making this offer, it was clear that this would not lead to a contract, would not lead to signing an agreement, because it was below what InterDigital would expect. But what is more, what was far more criticized by the court, even considered to be unacceptable in insisting on this rate, was the fact that this rate was based on an agreement that was lying back in the past. And the court said here, particularly, it was unacceptable to insist on this rate, which was more or less determined based on an agreement with LG, on the agreement with LG, which was an agreement from 2017, which not only was, let's say, signed in 2017, but if you remember, we said already it covered a period starting in 2012. So it was more or less an agreement which mirrored a value of the portfolio for almost 12 years ago. What the court said here is that irrespective of whether the adjustments made in the front determination in the UK were correct or not, what you at any case and at least should have done here was to take into consideration the inflation until the end of the license of the new license term. So this is the minimum that you should have done. The court did not say here that the front determination in the UK was not correct. We're going to see in a moment it had some questions on that, but did not say that it was not correct. But what it said basically is if you use a value of the portfolio that was agreed upon by the parties many years ago, a decade ago, what you need to do is to take into consideration the inflation in the rates that you're going to offer going forward for the future. And according to the court, a conservative estimate would require an adjustment of 30%. This meant that any rate below $0.2275 would be evidently unfranked, meaning any rate does not, which would not consider this 30% adjustment would be evidently unfranked. And this would apply even if you presume that the rate determined in the UK by the High Court was franked. So in any case, what should have been expected by Lenovo is, even if they wanted to insist that the front determination made in the UK by the High Court was correct and was franked, they should have taken inflation into consideration and should have added 30% to this rate determined in the UK. They did not do that, and in the eyes of the court, this was unacceptable. It made the offer, because it was below this rate that would include inflation, it made this offer unfranked and this behavior unfranked. Now, we said that the court did not really go into the details of the front determination in the UK, but it expressed the view that it is questionable to which extent the UK front determination can have a guiding function in the Munich trial. So again, it did not go into the details. It did not contest the rate determination as it was performed in the UK, but it asked itself whether it would play a role or could change in any way the decision of the Munich court in these proceedings here. And it basically said that you need to be cautious in the sense that despite the length of the decision of the ruling of the UK High Court, the determination of the specific rate, so the outcome, basically the result of this of the ruling, was supported by a very short explanation. And the court said also an explanation that does not provide a mathematically plausible reasoning. So here the court expressed some doubts on, not so much on the methodology, but basically on how well established the decision was at the end of the day, because indeed this ruling, the front determination ruling, was a very long one. If I remember correctly, I think the judgment was around 200 pages, with a very detailed analysis of the arguments of the parties, of the examination of the expert witnesses in the proceedings, etc. But the Munich court felt here that although there was a lot written in this decision, when it came down to how the specific rate that the court set here was determined, the explanation was not very comprehensive or was not very plausible, not very transparent, maybe. And there was one issue particularly which the court highlighted, that was the fact how the court decided, the UK court decided to apply the specific adjustment ratio to the 2017 LG license. So if you remember, we mentioned that in the beginning, We said that in the first step, the High Court in the UK had said that this LG license from 2017 is the best comparable, so is the license that should be used, and then applied this adjustment ratio in order to, let's say, take into consideration the differences that are there between LG and Lenovo, and chose to apply the specific adjustment ratio of 0.728. The court found that there was not a sufficient explanation or reasoning why this specific ratio was chosen. So the Munich court here found that the decision from the UK does not really explain why this adjustment ratio was the right one for the present case, and especially why it was chosen over other options that have also been discussed in these proceedings. And what was also highlighted by the court here was that this ratio that the court actually used was even below the lowest ratio that the Lenovo's own expert had presented in the proceedings in the UK. So there, in the UK, the expert that was hired by Lenovo to make this unpacking and to make these adjustments was having a range of different ratios that would come into question for applying that to the LG license in order to come to the Lenovo rate. But the court then adopted, in the eyes of the Munich court here, a ratio which was below even the lowest that Lenovo's expert suggested. So the court would have expected that there was a justification for that or a reason for that. And in the eyes of the Munich court, this explanation was missing in the decision of the UK court. So all in all, the court here expressed also some doubts about whether this determination in the UK would merit a specific guiding function here in the Munich trial. But nevertheless, I think the most important point was that using this rate, irrespective of the criticisms that you have, without applying this adjustment to consider inflation was the main aspect here in the proceedings. It's interesting, however, to see that apart from this point, which the court made very clear, there were also some, let's say, more comments that affected more the content of the decision and the reasoning of the decision. I think that's something that is interesting in this case as well, because the court, although it did not go into the details, it expressed some thoughts about the rate determination, which can be conceived also as part of a criticism of the decision itself.